As I mentioned earlier, Estelle and Kennedy is a full-service law firm, and we handle pretty much all of the major litigation areas. Family law, civil litigation, contracts, a lot of estate planning, which I find that surprisingly many people don't think about, but we do a lot of estate planning. We do also asset protection types of issues. We have some criminal law department. So we're a full-service law firm. What we don't do workers' comp, we don't do bankruptcy, but we do also do some of the federal type cases like immigration as well. Collectively, we have over 30 years of experience, 3 offices, as I mentioned, Upland, Los Angeles, and Irvine. My background relative to father's rights is interesting. In 2001, I established a firm called Child Support Liberation, and the objective was to help many men at that time address some of their child support, child custody issues. There were very few, actually there weren't any companies that men could go to and get help, and men typically were on the obligation side of the equation, and there just wasn't much there. So since that time, we've handled probably close to 1,000 cases, ranging from simple driver's license releases that needed to be obtained to custody visitation rights, a number of different issues that pertain to child support, child custody for men. So the fact is that whether you are involved directly in a custody visitation or support issue, most of us, either directly or indirectly, have had some experience with that. Family members, friends, co-workers. This figure, this percentage, I had one of my associates pull up yesterday, and I had her research it because I couldn't believe the number. Yeah, it was shocking. Right, and I've got some supporting information out of it. In California, now that's not the national average.
Yes.
The national average is about 53%. But California.
And when were those stats taken?
When?
Yeah.
Oh, that came up 2013. Yeah. Wow. Yeah, very, very disheartening. And this is a 2007 stat nationwide, how many births to unmarried women. So you've got an extremely high divorce rate. You've got an extremely high rate of mothers giving birth to children out of wedlock. All right, so let's talk about the issue of child custody. I'm going to start with child custody visitation, then I'll go to child support, then I'll go to arrears, then I'll start touching on expungements and sealing records. All right, so for men, well, first of all, for any court in California, they use a standard to determine custody visitation called best interest. What's in the best interest of the child? Okay, that's the standard that's mandated by the courts. So there's 2 different methods of achieving custody and visitation as a father, and it depends on how you're classified. So if you are a married father and you separate, divorce, then you have what's called inherent parental rights. That means that you've got the same rights without a court judgment as a mother does. All right, so in that case, if you're separated, in most cases it's the man that leaves the home and the children stay there. You want to get custody visitation rights, you're going to have to file what's called a request for orders. All right, that gets you in court. The court in California will set a court date. They'll also set a mediation date, because anytime there's a custody visitation issue initially or through modifications later, the courts mandate that the 2 parents go to mediation first so that they can hopefully establish a parenting plan. If that doesn't happen, then you go to court, you've got to make your argument that it's in the best interest of the child to either live with you or they have visitation, whatever that's going to be, and the court makes an order. Okay, so that's if you are married, separated, or divorced. If you are an unmarried father, you do not have what's called inherent parental rights. You have to establish your parental rights through the court. So that means if you know a person that has broken up with a girlfriend, moved out, all of a sudden, girlfriend says, hey, you're not going to see your son. So you go over there, grab the son, and say, no, that's not going to happen. Guess what? The police are going to knock on your door and say, hey, give up the child. Okay, because you have no inherent parental rights. So you have to establish that through the courts. So you establish that by filing a motion in court a request for parental relationship, or vote for a court date, and then from there you go through the same procedure. You got mediation, you have to do a declaration of paternity.
I'm sorry for interrupting. So you're saying that if you're unmarried and you have a child, that you have no rights whatsoever?
I'm saying you have no inherent legal rights.
No inherent legal rights.
Right. Yeah. No inherent legal rights. You have nothing you can enforce. You have to establish the rights through the court. Because think about this. The mother can say, hey, that's not the dad. We're not married.
What if your name's on the birth certificate or on what's the father's
And that's a misconception a lot of people have. You know, that if your name's on a birth certificate that you have parental rights, and that's not correct as an unmarried father. You have to establish it through the courts. It can be done in a couple ways. The traditional way through the family court would be just as I described. File a request for parental relationship, and then an RFO, request for orders for custody visitation. All right. Now, so let's say you've done that. You've gotten court order custody or visitation rights, and so let's just say they're visitation rights. And you have visitation with your son every first, third, and fifth weekend of the month, you know, from 6 o'clock p.m. on Friday to 8 o'clock on Sunday, which is pretty standard. And you go to pick up your son, mom's not there. Or let's say you get a new girlfriend, which happens quite a bit. All of a sudden, cooperation goes. And so she's not there. Says you're not going to visit. So what do? I can tell you what a mistake a lot of people make is they just don't do anything. All right, they just say, hey, she won't let me visit. Okay, but that's not going to fly because the court says if you have court-ordered visitation rights, okay, then you have the power to enforce those rights. All right, so how do you enforce those rights? You document 2 to 3 times when she has not allowed you to visit on your scheduled visitation date. You have the police come with you, and they give you a little card that says, okay, we've been there. After 2 or 3 times, the reason I say 2 or 3 times because anybody can make a mistake, but after 2 or 3 times you see a pattern, then you file a request with the court for contempt action. That's how you enforce it. All right, contempt action. Now I've handled a number of contempt actions, and I can tell you right now, I've been in court where the judge has read the rights to the mother. Okay, they take that very seriously. All right. So, but if you don't do that, you can't go to court and say, well, I love my child, but mom won't let me visit, because they're going to say, wait a minute, why are you so passive? You have to enforce your rights. You have the right, you have to enforce it. Okay, that's how you enforce custody visitation rights. Also, if down the road, child gets a little older, mom's having trouble, you feel that the child would be better served in your custody as a particularly young man, and you want to petition the court for full custody, well, if you haven't maintained even your visitation rights, the chances of you succeeding are pretty slim. Okay. So you've got to do that. Also, I always encourage my male clients to maintain a calendar of visits. That's important, and you'll also see why that's important on the child support end. Okay, any questions on child custody so far? I'm going to switch now to child support. All right, child support is determined in California by what's called guideline support. It's a computer program that's used. San Bernardino County uses the X-Files. LA County uses one called DiscipleMaster. They're all the same. It's a computer program that is mandated by the legislature to set child support based on certain elements, certain factors. Okay, those factors are, number 1, how many children? Number 2, what is the custody visitation percentage? Number 3, what is the income of each parent? And then there's several other factors, hardship deductions. For example, if you have other children that you have to support, that's factored in as well. All right, so once that information is accurately put into the program, then that program is going to determine how much you pay in child support. So the question that comes is, well, what if it's too much? What if I can't afford my car note or my house note? Well, that doesn't matter, because in the state of California, the number 1 priority of a parent is the support of their child. It's like church. If you understand tithing, they say you tithe from the top of your gross and you adjust your standard of living after that. Well, it's the same with child support. All right, so you're going to put the information in. The court's going to determine how much you pay, and that's how much you pay. If you have to trade your car in, to get a lower car note, or you need to make some other adjustments in your social life, that's the way the court's going to determine. That's what they believe, that's what they're going to enforce. All right, so we fail on when it comes to child support, because we have clients who are visiting with their kids on a regular basis, and they have what's quantified as a court order, say 20 to 25% custody. So for child support purposes, if your visitation is quantified to be 20%, that means you're going to pay child support for 80% of the time the child is away from you. So you can clearly see that the more custody visitation you have, the less child support you pay. All right. And the courts want you to exercise visits, not just the order. If you have an order for 30%, but you're only visiting 10%, guess what you're going to get? 10%. That's why you need a calendar. Because the other side is going to say, he doesn't visit. But if you have that calendar, and you have dates marked on it, you know, we're on this date, on this weekend, we were at Disneyland, here's the tickets, you know, that type of thing, then you can prove to the court, if need be, that you actually are exercising your custody and visitation.
There's a thing that I was introduced to called Our Family Wizard. Can you elaborate on that a little bit? Or?
Our Family Wizard is something that's used for parents who cannot communicate directly with one another, for parents who are mistrustful. So Our Family Wizard is a computer program that a lot of the courts will mandate that the two parents use to communicate issues like school activities, doctor appointments, anything else that might be relevant. And that program, once information is entered, cannot be tampered with or erased, and the court can access that. So how does that work in reality? If you have a parent who says that, hey, I keep calling the other parent, requesting information, she won't give it to me, court orders, okay, both of you sign up for Our Family Wizard, and you avail yourself to that twice a week. And anything that's relevant to the child, then you need to put on Our Family Wizard. So now you have something provable to the court, if in fact there are some disputes as to the honesty. Any other questions regarding the child support orders? There's much more to it than this. I'm just giving you the basic framework for the sake of time. Yes.
Question, how long is the person going employment? How does that work out?
That's good.
The child, well, the way you're talking about the obligor or the obligee?
The obligor.
All right, so on the obligor side, unless there is a legitimate legal reason not to work, then the court can order a work search. Okay? Or what we do, if we're going up against a person that has skill, capable of working, but is not working, we will ask the court to impute income to that person based on that person's capacity to earn. So that means if you have a person who's got a master's degree in business and they're saying, okay, I can't find a job, then we will ask the court to impute income based on that person's qualifications and what they're capable of earning, and then plug that number into the Dismaster X spouse to calculate child support. And that works both ways, with obligee as well.
I had another question in regards to, a lot of times we have these individuals coming out of the prison system. Once they're incarcerated, does the payments continue to
accrue? Now I'm going to touch, that's a very good point, so I'm going to touch on that when it comes to arrears. But I will say initially that if a person's incarcerated at the outset, then their child support order will be zero. But if they are incarcerated after an order, then over the last 8 to 10 years, then the courts have enforced an automatic modification to zero. Prior to that, if the party did not file for a modification, they're going to get out of prison with a huge arrears obligation, which is really sad because I see people owing hundreds of thousands of dollars. They have no capacity to pay. But if it's owed to the other parent, then they're going to have to pay it unless that other parent decides to settle it. Okay. All right, so, and getting to child support. So let's just say that initially, a person's ordered to pay $1,000 a month, and they lose their job. And this happens quite a bit. A big mistake that's made on the part of most fathers is they do not petition the court immediately for a modification. So what happens? That leads to arrears. Right. And then they come back, 6 months, a year later, and say, oh, I didn't do it because I figured, I can go in and let the court know that I lost my job and they'll modify it. No, no. The court does not have the power to modify a support order retroactively. So it's modifiable only back to the date that you file the motion for a modification. And that's a huge mistake, because if you're strapped with $100,000 in arrears and you're 28 years of age at 10% interest, it's a tough deal. And you can't discharge it through bankruptcy. All right, so I'm going to move over to the Department of Child Support Services. Anybody know what that is? CSSD, Child Support Services Department. Okay, that is the agency that establishes and enforces child support. Now, don't get confused on this, because the family law court will set child support orders that are not going to be necessarily enforced by the state. All right. But if it's going to be enforced by the state, if the mother was receiving welfare benefits, then automatically the state becomes the payee. Okay. Or if there's an existing order and the recipient takes that order down to DCSS and asks the county or the state to enforce it on their behalf, they will do that. Or they can establish the order themselves. I'm going to go through that just a little bit. Okay, so if a judgment is obtained by DCSS, what they will do procedurally is they will go ahead and file a summons and a complaint, and they'll serve it on the father or the person who's identified as the father. Now I want to back up just a moment, because everyone knows about welfare fraud. All right, this is an area where, in my opinion, there needs to be some major legislative changes in how this is done. But the typical welfare fraud scheme happens like this. You'll have a mother who's pregnant, gives birth to a child. She knows who the father is, or maybe doesn't know, but she's got a friend that lives over on East Street. She tells that friend, I'm going to go ahead and file for welfare, and when they ask me who's the father so that they can go collect from that person, I'm going to say Tommy Smith is the father who lives over there in East Street. So when they file that complaint and serve Tommy Smith in East Street, they go and say, who lives here? Say, this is Tommy Smith's house. All right. Now Tommy Smith lives in Redlands, doesn't know anything about this, hasn't seen this woman in who knows how long. All right, so the DCSS, they file the complaint, the summons complaint, they serve it over to Tommy Smith in East Street. The person that lives there says, yeah, confirms he lives there. And they wait 30 days. They don't get a response, because you're required to respond within 30 days to file a response. If you don't, they get what's called a default judgment. Once they get that default judgment, Tommy Smith goes to work, picks up his paycheck, half his salary is gone. He says, what? Yeah, the child support wage assignment, garnishing. All right, so that's welfare fraud right there. And it happens all the time, where I get guys that come into the office and say, hey, look, they're saying I owe child support. I don't even know who this child is. I've never served, da 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 da. And I said, okay, we can handle that. So we can set aside that judgment. However, that judgment can only be set aside if the person files the request for a set-aside within 6 months of the day they knew or should have known that that judgment was entered. That should have known is really important here. So there is no actual notice, there was no statutory notice given to Tommy Smith, because he did not live where the county served. Okay, so he achieves that criteria. But if he does not file the request for set-aside within 6 months of the date that he got his paycheck and saw that the wages were garnished, then he's going to give up his right to set aside that judgment. He's just inherited a child support order for a child that may not even be his.
Wow. Did you know that, Ryan?
No.
Can he appeal that, or once that's done, it's a done deal, huh?
You have 6 months, that's the law. You have 6 months from the day you knew or should have known that there was a judgment against you. Okay, so you can't procrastinate. I mean, if a person takes half your paycheck, I mean, if you don't suspect that there's something, you need to move. You can't sit on your hands. Okay.
So DCSS has all his information, including where he works.
Oh, is the child support registry, right, is where they'll get your information, yes. If you're paying in,
So they don't.
if you're a W-2 employee, they know your work. That's no problem.
And they're just basically going off the information that the mother's saying, right? I mean, she's saying like, this is the father,
Right.
and it hasn't been, proven by any kind of paternity test or anything like that. So, she can just like.
She can name anybody.
Anybody, yeah.
That happens all the
They can
time.
go after.
Right. There's a lot of men paying child support for kids that aren't theirs. And they know it, but they can't do anything about it.
There's no recourse.
Well, there's recourse that I just told you about.
Right.
Okay? And there's also recourse, they've expanded the time that you can challenge paternity. Okay? But that's a completely different approach to what I'm telling you now. What I'm saying now, I'm talking child support. Now, if you succeed in setting aside that order, and I have never once not succeeded in getting a set aside, if my client's been honest with me. Okay, if they were not served, and I can show, all I have to do is go and get the court records, because a proof of service has to be attached to it, and find out when and where this person was allegedly served. If that person can show on driver's license or evidence they live someplace else, and they've come to us within that 6-month period of the time they knew or should have known, I will get it vacated. Once you get it vacated, then you file an answer that states, no, this is not my child, I request genetic testing. And they have to give it to you. If it turns out that you are not the father, then there's no further action taken against you. Okay? Yes?
What about like during your parenting time, the other party wants to like take a vacation?
Okay.
But it's your custody time with the child.
Well, typically when we do our custody visitation orders, it lays out, who has the child or children at particular times. All right, so if your summer vacation is the first 2 weeks in June, then that party cannot leave on vacation with the child, or if that party does, then you file a contempt action. All right. But now where people make mistakes, and even a lot of attorneys, unfortunately, that don't practice in family law a lot, they'll make orders that say every other weekend. They're vague. Now, how do you enforce that? You've got to go all the way, get a calendar all the way back to the very beginning to find out what that every other weekend will be. So we always specify 2nd and 4th, 1st, 3rd, and 5th. I typically, for my clients, say 1st, 3rd, and 5th. So I want to talk briefly about child support arrears, how that's calculated, how it can be handled. All right, so child support arrears is simply what a person might owe if they have not paid the child support obligation in the manner that it should have been paid. All right, so in California, if your child support order is enforced by the DCSS, then you're going to be charged 10% for any past due child support, any unpaid child support. That can be very hefty. Now, before the last, I think, 6 years, if a person was behind, say by $20,000, and they start making payments toward the arrears, the payments will be posted to the interest first. Okay? Now this is simple, not compounding, so there's a column for principal, a column for interest. Problem is that the interest is determined by the amount of principal. So if you owe $15,000 in principal, you could very well owe, $25,000 in interest. All right? And so that 10%, if you take 10, that's the annual rate, and divide it by 12, you're going to get 0.833 times whatever that principal is going to go over to the interest every single month. So what happens is people will get behind by $10,000 and they never pay it off. It just goes on forever. So now they've changed that. So now they're posting to principal first. All right. So, but if you have a current child support order of $600 a month, you owe $10,000 in arrears, so you're paying an extra $150. This can go on and on and on and on. So it's imperative that a person who owes child support and no longer has the legal capacity to pay, it's imperative you file a modification immediately. And get your current support dropped to a level where you can pay, because once you get behind, it's a difficult situation. Now, if the mother was on welfare, the arrears that's owed will be owed to the state. If she wasn't on welfare, it's going to be owed to the mother. Okay, and that's important in terms of how you can settle this. We always do an audit because DCSS makes a lot of mistakes, and we found where they posted payments to other people's cases. So, always keep records. It's amazing Our female clients come in, they know dates, they've got receipts, they've got every detail, they can tell you the social security number of the other party. Our men come in, they don't know anything. You know, they don't know when they make payments, they don't have receipts, you know, they don't know where folks live, we got to do investigation. You know, it's amazing. So I would just advise men to keep notes, you know, be a little bit more observant, always keep receipts and a record of payments. All right, we do audits. There's also settlement options. If the arrears is owed to the state, then the state has a program called the co-op program, which is Compromise of Arrears program. And if you can show that person's incarcerated, for example, they get out, they owe $100,000, they have no capacity to pay, all of it's owed to the state, then the co-op program can be successfully used to get that significantly reduced. We've had it reduced from hundreds of thousands of dollars down to $5,000, $6,000.
Can I ask a quick question?
Sure.
If the money is owed to the state, why is the money owed to the state when it's actually money that's supposed to be paid to the spouse?
Well, the reason why is because they've advanced the money.
Okay, so the state
They're
pays
welfare, right.
it. The state pays it to the spouse in the form of welfare.
Our spouse or mother.
Okay,
Right. So once that person, once the state establishes a judgment, when they're giving services, then they become what's called a substitute payee. Okay, so that means the money goes to them. So they're advancing the money. Otherwise, that child receives nothing, right? You got a father that's not paying anything. You got a mother that's not working. Okay, that child becomes what's called, I don't mean this in a derogatory sense, but they become a financial burden on taxpayers. Okay, so this person that's not paying has to reimburse the state for taking care of this child at a 10% interest.
One of the problems is fathers usually go in and say, well, I bought the diapers, I gave them $100 here.
Right, that doesn't work. That doesn't work.
Show, you know, of course.
Well, they say well, you're supposed to do that. Okay?
Exactly.
You're supposed to do that. All right. So the co-op program can be used if it's owed to the state. If it's not owed to the state, if it's owed to the other parent, then you got to negotiate a settlement, if possible, with that other parent. And sometimes it happens, sometimes it doesn't. Typically, if you can offer a lump sum cash, we've had mothers who have significantly reduced the arrears. But if they just have an extra grind, forget it. All right. Okay, I'll start with sealing arrest records. Sealing records is something a lot of people don't use, but they should. Many men have been arrested, but have not been convicted. I would venture, I'm not asking for hands, but I would venture to say in a room this size that 70% of us have at least been arrested once. It might be protests, it might be for legitimate reasons. Most people don't move to seal their arrest records, and that's easily accessed. If you're convicted, that's expungement, but if you're not convicted, if you've been arrested and not convicted of a crime, then you can have that sealed. Okay, there's several steps to do that. There are criteria. District attorney did not file any charges. That could be a reason, or the charges filed were dropped. The judge found the applicant not guilty of the charges. So even if you're applying to have your record sealed, you still have to show the court that there's little likelihood that you were guilty of that. Because of course a lot of people aren't prosecuted not because they aren't guilty, it's just because maybe a witness, decided not to testify or was no longer around. But everyone knows that person's guilty. In that case, it's going to be harder to get it sealed. Once the arrest record is sealed, that means that record is no longer viewable by the public. And then after 3 years, it's removed completely, no longer exists.
When you say the public, does that mean employers too?
Under seal, yes. It no longer exists. Okay.
So with the way the internet is today, there's no way they can find this out, or?
No, I would never say that.
Okay.
No. I mean, if a person wants to dig, oftentimes they can get information. But, a lot of employers, they just do the cursory check.
Exactly.
They don't really go into that kind of detail. But if you're running for a public office, if you're running for the U.S. Senate, it's going to show up somewhere. Okay. Expungements. Expungements are different. That's if you have been convicted of a crime. Okay. Not just arrested, but convicted. An expungement is a dismissal of the conviction. All right, so you're convicted, you pled no contest. It's typically a misdemeanor or even certain felonies, but if you were given county time or if you're on probation, then typically, and it's not a sex crime, certain sex crime, then typically you will qualify to file for an expungement. All right, infractions, misdemeanors, felonies. Okay. But if you were given state prison time, you cannot expunge that. It's not going to happen. Yeah, you know, I'll give you a quick story before I finish it.
You know, one thing is, Mr. Leading, is that we say expungement and seal, being sealed, but when it comes to law enforcement, it seems it doesn't cross that line, because if they pull you over, they're still going to pull up your record, and it's going to come up. I mean, for law enforcement. And
well,
we say, oh, it's not supposed to.
Right.
But in most states it will.
Well, let me tell you how it works. If it's an expungement, it doesn't disappear.
Yeah.
Okay, you got to understand that it shows as a dismissal.
Yeah.
Okay, in the Department of Justice. Okay, or if you run a live scan, which is FBI, it's going to show as a dismissal.
Right.
But if your record is sealed, then after 3 years, it disappears. Okay, so that arrest will not show up.
Yeah.
So, I mean, I know a lot of people who have applied for different types of jobs with their record sealed, and they have not shown it. So that's why I'm emphasizing getting a record sealed if there's been no conviction, because as I said, a lot of people are arrested. You know, I mean, that just happens, and a lot of you can be arrested for pretty much anything.
Because that's the main thing, because cops can cite you on several.
You can be arrested.
Right. And all of that
It's on your record,
the
right.
court, all that
Yes,
comes
yeah.
up, you know,
Right.
on this count, on this count. And after the judge go ahead and dismisses the case, then they're still stacked up there on the record.
Right. And I agree. So that's one reason I'm emphasizing this. Again, my name is Michael Kennedy. I'm a senior partner for Estelle and Kennedy. If you do need to call and speak with us, we'd be happy to work with you. Thank you.
Like we appreciate